graduate programs here at Albany Law School. So I just wanted to start off by saying that this session will be recorded and it'll be made public tomorrow. So thank you again for joining us. And here at the online graduate programs, we have a master's degree, an LLM degree, and a certificate program all online. We were recently ranked the #1 most flexible program in the country, and we have our next start date starting in January if you are so interested. We have concentrations online in cybersecurity and data privacy, financial compliance and risk management, and health law and compliance. And so I just wanted to mention that if you're interested in more information about that and scholarship programs that we have available, feel free to send an email and connect with Mary Puzikowski, who'd be more than happy to speak with you. And without further ado, I will turn it over to Mary, who will be introducing our special speaker and professor in our program tonight. Thank you very much for coming.
Thank you. All right. So hi, everyone. I'm Mary Puzikowski, Assistant Director of the Online Programs at Albany Law School. Thank you again for joining us tonight for our first online lecture series. Tonight from our cybersecurity and data privacy program, we have Joseph Swish. Joseph is an incoming professor at Albany Law School, and he'll be teaching a compliance officer course. He has spoken at different national conferences, including Global Ethics Summit, Utilities and Energy Compliance and Ethics. He also has years of experience as a compliance and privacy expert. So we are lucky to have Joseph as part of the Albany Law School community, but also fortunate to have him here tonight to present a seminar on the GDPR. Before I turn it over to Joseph, I do ask if we can please put questions within the chat box. We'll see time at the end for questions at the end of Joseph's presentation, but we'll also be able to email Joseph for the questions. So without further ado, I turn it over to Joseph, speaker tonight. Thank you, Joseph.
Thank you, Jason and Mary. Can everyone hear me?
Yes, everyone can hear you.
Okay, great. So folks, tonight we're going to discuss European privacy, in particular GDPR. Privacy, I think right now is a very timely, a very relevant topic for those of us in compliance. And it's very much on the mind for those of us in organizations on boards of directors, really sure who owns privacy. They're not sure of the complications or the consequences of privacy. I would say right now, cybersecurity and privacy are two of the biggest issues on the minds of board members in most organizations from a compliance standpoint. Similar to maybe EHS was 35, 40 years ago when rivers in Chicago were burning, when there was terrible tragedies in India with Union Carbide. There was a lot of concern. Since then, there's been a lot of development on environmental law, Clean Air Act, Clean Water Act, Superfund. There's been a plethora of environmental consultants and EHS lawyers and some very top quality EHS in-house folks. But now we are dealing with privacy, and boards are very concerned with privacy. It's a black box to a great extent for them. And tonight we're going to talk about some of the basics of the new European privacy law. It's going to be an espresso shot, if you will. If you're a privacy expert, you're probably not going to learn very much new on this, but this is going to be some of the basics of what you need to know, even as an American, if you're working for an American company, on the GDPR. Okay, on the next page, if you're following along, the GDPR is the General Data Protection Regulation, GDPR. It was enacted in 2016, and it went into force 25 May 2018, which means if you're subject to the GDPR, there is a host of requirements and procedures and reporting and things of this nature you have to be doing right now. And if you're not doing that, you're probably in violation of some of these GDPR requirements. One of the main goals of the GDPR was created to help synchronize data privacy law and regulations across the EU. Now, it's actually not just the EU, it's actually the EEA, the European Economic Area, which I think, if my memory serves, it includes all of the EU, as well as Liechtenstein, Norway, and Iceland. I think those are the other three, but there's about 27 countries in the EEA. We'll use EU for our parlance tonight, but know that it is actually a little larger than just the EU. So it's helped us synchronize laws across the EU. I remember when I was a chief compliance officer in Prague and in Moscow and in Zurich, we would have to go to individual data privacy offices to say we are doing perhaps a conflict of interest electronic form. This is going to use our workers' individual privacy and personal data, and we want to make sure it's okay. We had to go, and each one, while they were all following European directive, each member state had implemented a different type of rule or different rules. It was extremely difficult to figure out which one to follow and what the changes were and what was required of each state, each member state. Now that's all in some ways synchronized across the EU, though the GDPR does allow for some flexibility, and there will be some tailoring toward that countries are allowed to do. But in general, I think a big takeaway is that it allows for synchronization of the privacy laws across Europe. That's probably takeaway number one. The second one is it gives, and we'll call individuals in the EU data subjects. That's how the GDPR calls them. This is a law full of terminology, and we'll discuss some of that tonight. Data subjects in the EU are given more control over how their personal data is used, and that's really a huge part of the GDPR. You'll see that unlike in the US, the Europeans look at privacy in a different way, data privacy in a very different way. There's been a variety of assumptions of why this is. I think probably the right one is historic reasons. There have been there's been issues with what trade union you're in and enforcement by secret police and atrocities based on religion. So a lot of people want their data privacy kept very closely held, and they want to know about their personal information, how it's being used. Now you may say, well, I work for an American company, or I plan to work for an American company, or I plan to work via outside counsel or a lawyer in the US. What do I care about the GDPR other than this is a nice to know? Well, it's more than a nice to know. Because if you were a company outside the EU, but you're providing, and we'll go into more definitions deeper in the deck, but if you're providing goods or services or monitoring the actions of individuals in the EU, and you're using or processing personal information to do this, you are subject to the GDPR, which means you could be subject to the GDPR even though you're physically located outside the EU. This is a big deal. You could be subject to the GDPR as a company, even though you are located outside the EU. And the GDPR also creates a lot of requirements for those collecting data, controlling data. We'll call them data controllers. We'll go into these definitions in a minute. Or those processing data on behalf of the data controllers. There's a lot of requirements. Some of those are very similar to what the European company had to do under the European Privacy Directive, very similar, but some are new. And some would be very new to what Americans think of when they think of privacy. When Americans think of privacy, we always think of privacy in sectors. The healthcare. Many people are familiar with HIPAA or have a general sense that HIPAA allows some type of privacy with their medical records. With the GDPR, it applies across all personal information. It doesn't have to be simply a sectorial type of factor. It applies across one's personal information in all sectors. And the fines for the GDPR can be very serious. Now, this is the most drastic and draconian, of course, but it's 20 million euro or 4% of global revenue, whichever is higher. Now, if you're Facebook, that's over $1 billion fine. If you're Amazon, that's 7 billion plus. So these could be very, very serious fines. Now, no fine of this nature has yet been issued, but GDPR has only been around a year plus. And there have been certainly fines in the millions. And this, of course, means the level of the fine, as with any law, is dependent on how egregious the violation is, what your intent was, and what type of violation it is. Now, the GDPR is something which is affecting companies globally. It's affecting companies globally. Yes, it's affecting companies globally because if you're selling goods services, monitoring individuals in the EU and using their personal data, processing personal data applies to you. We know that. But it also affects companies because companies often don't have the resources or the cash flow to go and create a separate privacy program just for your European division. So what they will do is make their privacy rules, procedures consistent across the company globally using the most stringent laws, and that will be the GDPR. So oftentimes you'll see companies applying GDPR standards globally, even though not all operations are impacted by the GDPR. Mary, there's quite a bit of feedback on the phone. Can we ask folks to make sure they're on mute if they're not asking a question? Okay, going to the so those are the takeaways. My old boss would always say, "You lose people in the first 5 minutes." Those are the things I think you got to know about the GDPR. It's in effect now. It synchronizes privacy. It really provides much more control to the data subject about how her or his personal information is used. It can apply even if you're outside the EU. And there's some serious potential fines if you have a series of egregious violations of the GDPR. Okay, now where does it apply? Well, certainly it applies, as we said before, to any organization established within the EU. That's the language we find in the GDPR. Now, what does that mean? Well, it means if you have an office or branch office or employees in Europe, you're going to be subject to the GDPR, even if you're processing your data outside of Europe, which is an odd thing perhaps, but that's how the rule is written. Now, as we mentioned, organizations outside the EU that process EU personal data, we'll talk about what personal data means in just a minute, when they're offering goods or services or monitoring the behavior of individuals in the EU would also apply. Now, Mary, I'd like, if the folks don't mind on the phone, and I'd like to make it a little more interactive, let's see what the chat boxes say. I'm not looking at the chat box, Mary. You can kind of tell me what people are saying. Let's go with this first one. What do people think about this? So I'm a U.S. tourist, and I'm using a travel app, which is processing my personal data in the EU. I'm a U.S. person. I'm traveling in the EU on vacation, perhaps, or holiday, as you'd say it, and I'm using an app, and that app uses my personal information. Does that data, is that control, that person running that app subject to the GDPR? What do people think there? Please write your answer in the chat box.
People are saying yes, absolutely.
Yes, that's right. That's right. It is. It is, sure. I'm an EU citizen, and I'm using a travel app in the US. What do people think about that?
Again, yes.
Well, wait a minute. Let's look at the test. I am not an organization. I think the answer here is no, right? We're not in, I may be an EU citizen, but it does not simply apply to you because you're an EU citizen. It applies to individuals in the EU. At that point, I am not in the EU, right? I'm traveling in the US. So there, the GDPR would not apply. It's very confusing. And believe me, folks, we're going to get into some very confusing scenarios. And this is why it's very interesting to be a privacy officer right now. This has been around a year. Yes, it was established in 2016, but and even then it was created. It took years and years to create. So it's already behind the times as far as the technology. But this is why it's very confusing, and guidance is being put out now, and people are very confused, and they're trying to create programs that work, but it's some tough stuff. Okay, a U.S. citizen working in the EU. Now that would apply. If someone is processing my data when I'm working in the EU, that would certainly be subject to GDPR. What if I'm a U.S. Here's a tough one. What if I'm a U.S. shoe sale website? So I sell shoes in the U.S. If that was the case alone, and I'm simply have a website, and someone from Europe goes and uses my website, would that mean I'm subject to the GDPR? Probably not. But But what if I then added French language or allowed people to pay in local euro currency? The GDPR would most likely then apply, because my intent is then to avail myself of goods and services and process that data. U.S. citizen EU using a website using a U.S. news website. Now, this is an unusual one. I'm just reading this from the guidance. The guidance here said from the Privacy Board guidance, and it said no, it's not. And we also know that monitoring behavior of individuals in the EU when you're processing the personal data can also trigger the GDPR. What's monitoring mean? Just a couple examples: cookies, tracking, closed circuit TV. Okay. Also, and we'll go into this more, organizations must appoint a data protection officer. I remember when the CERCLA, the environmental CERCLA came out, law CERCLA, known as the Superfund, came out. We used to kid it was the Environmental Attorneys Employment Act, because it kept so many of us busy at the time. I think the GDPR in some ways is the Privacy Officer Employment Act, because it is, not only is it a confusing law at times, it requires that a data protection officer be appointed by companies. It requires that. You don't see that too often. It requires it if you're a public authority or if you're regularly and systematically monitoring data subjects or sensitive data on a large scale. We'll talk about what sensitive data is in a minute, but as an example, sensitive data would be religious status, sexual status, things of this nature. So there's even requirements to appoint a DPO, or data process officer. Okay, so we know there's a territorial scope to the GDPR. It doesn't apply everywhere, but it does apply certainly in Europe, and also maybe outside of Europe if I am doing certain things in Europe. We also know that it deals with information, but it deals with personal information and the processing of personal information. Processing of personal information. So what is personal information? What does that mean? Well, GDPR says any information relating to an identified or identifiable natural person. We call that the data subject, as I said before. That's an IP address, location, name, birthday, bank info, social media posts, photos. All this is personal information. This may be unusual or sound overboard to an American, but to Europeans, this is considered data which they feel they have a right to control. Identifiable is an important word here, because it's not only saying Joseph Such, professor of law, Albany Law School. It's probably not Joseph, because there's a lot of Josephs. It's probably not Joseph, the law school professor, because there's probably probably a handful of those, which would not allow me to identify me. But if we start saying Joseph, law school professor, Albany, then I probably could be identified with those elements of data. So watch how you also stack the data, which then conform, or which data you're using, which then could become identifiable. Another there's special categories of data, sensitive data. And it makes sense. This is sensitive stuff. This is race, religion, health data, genetic data, trade union. Here we go back to history where certain trade unions were exploited and discriminated against in Europe. Trade unions, sexual orientation, political views, and criminal offenses, which are still regulated by authority. So not all PII is the same, and not all PII carries the same enforcement risk. If you now are thinking that you may have some GDPR tail liability and you need to start putting a GDPR program in place, what's the thing you do first? Go to your sensitive data. Control that first. That would be the first data I would address. Okay, so we know that the GDPR applies in Europe and also maybe outside Europe if I'm doing certain things in Europe with processing personal data of European individuals. We know that it really applies to personal information or sensitive personal information. It doesn't apply to everything. And you basically have 4 types of players, if you will, in a data set. You have the data subject, which we talked about. This is the person whose data is being collected. So she or he is the employee, she or he is the customer, and their personal data is being used. Now, who's it being used by? Well, it's being used and controlled by the controller. This is the person who is obtaining and using that data. Now, they may be processing that data themselves, or they may be hiring someone on their behalf to process that data for them. We'll go into some examples in this in a minute. And there's also a supervisory authority. These are the four elements of the data set. A supervisory authority, or sometimes called a DPA, Data Protection Agency, is the enforcement agency. Each member state, all 27 have one, have a DPA, all 27 member states of the EEA. And if I'm a company which has multiple offices across Europe, I get to pick. But I don't get to pick randomly. I get to pick based on where my main processing takes place. Now, there is some form shopping. The Austrian DPA seems to be picked quite a bit. I don't know if that's because they are more business friendly, or maybe they have more resources, but it's oftentimes people pick the Austrian DPA. Okay. So I have to decide whether I'm a data controller. Data controller is just like what we said before, but definitions are important with GDPR. Person or entity, which alone or jointly with others, determines the purpose and means of processing. So if I'm, for instance, a bank and I collect the data of my employees, I need to do that. I need to make payroll and provide payroll, or need to submit information to the government. I'll collect personal information from my employees. I'm a data controller. I might do that for my customers as well. A customer wants to make a deposit. I have to know the BSA who she or he is, where the money came from, what their social security number is. I'm collecting personal information. So I'm a data controller. A data processor is a person or entity that processes the PII, processes the personal information on behalf of the controller. The processor does not decide how it will be collected, what will be collected. The processor executes the processing as directed on behalf of the controller. So in this example, a bank contractor hires a subcontractor, a bank hires a contractor, and that contractor processes bank information. It processes bank personal employee information to make payroll, distribute payroll. That is a processor. The bank is a controller. And what does this matter? Who cares? Whether I'm a controller or a processor? I may think I'm a processor, I might be a controller. Well, you got to know who you are. You could be both as well, because specific requirements apply to both, particularly the controllers. A lot of requirements with the controllers. What are some of those requirements? Well, technical and organizational measures. If you take the privacy exam for Europe, for the GDPR, you'll hear this a lot. Now, what does that mean? Well, it's not expressly defined of what that means. It's security measures, it's encryption, it's limiting access across your organization, it's physical security, it's periodic security reviews, it's security measures based on your company's individual risks and your company's available risk mitigants. So I think smartly, the lawmakers of the GDPR did not want to tailor one size, though that would be easy, because if I do A, B, and C, then I'm in conformity. They made it that you have some flexibility based on your risks and what available mitigants you have. Unlike the example I gave before, where I have to go to the agency and say, here's my program, is it okay? Here's my submission for my ECOI, is it acceptable to you, Slovenian Data Privacy Authority, or Croatian Data Privacy Authority? Here it's somewhat self-enforcing, self-regulating. You have to hold yourself accountable. If there's an inquiry, if there's an investigation by a DPA, you have to demonstrate that you're in compliance with the GDPR. So there's an accountability that runs throughout the GDPR that you have to be able to document and show that you're in compliance. The requirement of, and these are terms of art, which you'll hear a lot with privacy in the GDPR, privacy by default, privacy by design. Let's say I launch an app. Well, the app needs to be set with the most stringent privacy settings, the privacy by default. Let's say I'm creating a new software program. I need at the early stages to build in privacy controls and privacy inquiries to make sure I'm in compliance with the GDPR, privacy by design. We're not going to go into this tonight. It's just it's another layer. It's 202 versus 101 basic GDPR, but I have to conduct certain inventories and also impact assessments for projects. And you have to keep records of the process. You always have to show that you are accountable under the GDPR. Okay. Data breaches. Inevitably, you're going to have some type of data breach. And you have to have a process in place to identify it, respond to it, and eventually remediate it. And report it, but not always. You must report data breaches to the DPA without undue delay, but at least within 72 hours, and that's fast. Now, it's once you become aware of it, so it's not a breach may have happened, you weren't aware of it, but once you become aware of it, you have 72 hours to report that breach. So if that means if Mary, who is in your sourcing department, improperly hands out personal information of some employee or some customer to one of their vendors, learns of it, goes away over the weekend, comes back on Tuesday or Monday, and on Wednesday reports up to the lawyer or the privacy officer, oh, hey, by the way, I had a breach. You've already violated the GDPR. So you have to really train your employees that they need immediately to raise these issues to the privacy office. You have to have a system to do that. Now, you don't have to raise it to the DPA if there's no harm to the data subject. That's difficult. And we have to be very careful here when we're doing this analysis. We're going to look at the nature, the harm, severity, the volume of the breach. So what might not need to be relayed to a DPA? Well, maybe it was encrypted, so no one could get at it in the first place. Maybe it was only a website open for a short time. You got to monitor who looked. No one was there. You shut it back down. Maybe it was something which was sent to your lawyer who you trusted, who then deleted it, said, I did not read it, and then or returned it, or maybe returned it. Maybe it was publicly available already. Maybe it was a website name or a email name, which you can find on LinkedIn. But you have to be careful about that. And generally, you have to be very concerned that if there is a breach, you are following the 72-hour rule. Now, do you have to tell the data subject if there's a breach? I have to say in many cases, perhaps not in voluminous cases, but many cases, I've always erred upon the old rule. I want to treat folks the way I want to be treated. If my data was breached, I'd want to know about it. But the GDPR does not require, in every case, that the data subject be informed. The data subject must be informed of the breach if there's a high risk of harm, if it's expected to cause a high risk of harm to the data subject. But you don't have to do it if it's a disproportionate effect, in the sense that if there's 400,000 people, you don't have to call everyone. You could do that by public notice instead. You don't have to do it if you took measures to prevent the harm, such as the website was open, you shut it down right away, and you can confirm no one looked at it. Or maybe it was encrypted. Maybe the data was encrypted and it was impossible to get to. So you don't always have to inform the data subject. And sometimes it's very, very difficult to do so if there's quite a few. Okay, so here's a question. Mary, I'm going to have you open up the, here. There you go. I can hear you. Okay.
Yeah.
So 25 May 2018, we know that's the day the GDPR came into effect. 22 May 2018, it's almost a year. So about a year, the GDPR has been around. According to the European Data Protection Board, how many data breach notifications were reported in this year? So this first year, how many companies reported data breaches at their organization? What do you think it is? A, 890, B, 8900, C, 89,000, or D, 890,000? Mary, what do people think?
Some are saying B.
Okay.
One said C, another B.
So my guess would have been B as well, but B is wrong. It's actually C. So almost 90,000 people reported data breaches across the 27 EU states just within 1 year. So it's pretty sure you will have some type of data breach in your organization and you better have a process that addresses it. Okay. The last thing we'll talk about for data controller requirements is that if you're going to hire a processor, you have to do it in a certain way. You certainly have to have it in a contract, and that contract has to clearly define the scope of what you're asking the processor to do. Remember, the processor makes no decisions by her or himself. They do what the controller requests them to do. You have to ensure that the data is still confidential. You can't give it to the controller and the controller just fail to execute on security measures or fail to keep the information confidential. If there is some kind of inquiry, the processor has to agree to support the controller, and the processor has to agree to return or destroy data at the end of the contract. Now, both the processor and the controller are liable. It's another big takeaway. Both the processor and the controller are liable for GDPR violations. And as I mentioned, this hasn't been a lot, but there's about a year, there's been 11 fines so far, and one has been in the 50 million range. Nothing has been, nothing has been 4% of global revenues, but again, that's held out as the most egregious type of maximum penalty. Now, a processor has easier requirements, but still not easy, but easier as compared to the data controller. They have to keep records. They have to notify the data controller if they have a breach without undue delay. They have to appoint, or they can't appoint a subcontractor without the data controller approval. As we said before, they have to keep the information secure. They have to keep it confidential. They may have to appoint a DPO based on the criteria that we talked about earlier. We're not going to discuss it tonight, but there's transfer requirements. You would not think that the GDPR requires all this security and confidentiality around its data while in Europe, and would then just allow its data to be shipped out of Europe with no such requirements. So if you're transferring data, there's certain similar requirements that have to be in a country or have to be in a company or organization for that data to flow. So they have to, the processor has to help on properly transferring data. We're not going to discuss this tonight, but again, I'm going to give you a link which will show you more on cross-boundary transfers. And you have to, again, this is important, stick to the data controller processing instructions. The processor does not go rogue and start controlling or processing that data outside those confines. Okay, so let's step back for a minute because this is a lot of stuff. We know that the GDPR is in effect. We know that it applies in Europe. It's also to companies outside of Europe that are doing certain things within Europe. We know that only applies, though, under that territory, under those territorial jurisdiction, if you are processing PII, processing personal information, as a controller or as a processor. You have to have those elements. Those are the elements you look at when you're evaluating applicability in the GDPR. But if you do fall within the GDPR and you are a controller and you're going to process personal information, and I want to say this a couple times, no processing can take place without a legal basis. Let me say that again. No processing can take place without a legal basis. If you remember nothing from this presentation, remember that. Unless you have a legal basis for processing the PII, you cannot proceed. And there's basically sixfold. You have 6 ways you can process legally. If you have consent. Now, this consent has to be freely given. It can't be coerced. It has to be specific. Mary gives me consent to process my data for purpose A. She didn't give it to me for, I can't use it for purpose B. She didn't give it to me for that. So only for a specific purpose. It has to be an affirmative act, which means I can't say to Mary, Mary, I'm going to process your data unless you opt out. Nope. Mary has to opt in. Mary has to go and check a box to opt in for consent. It has to be easy to withdraw. If it was easy for Mary to give it, it has to be easy for Mary to take it away. And I have to make sure I identify who the data controller is, the purpose of what I'm using the data for, and the possible impact it would have to the data subject as a result of the processing. I could also have a legal basis of to perform a contract. I have a contract to buy shoes. I need your credit card information. I need your name. I need your phone number. You give me that personal information, and then it's allowed through contract. That makes sense. It could be due to a vital interest. Jason could have a medical emergency, and I have to provide that data, that is personal information, his blood type, to make sure it's in the vital interest of Jason, vital interest of the data subject. Could be in the public interest, such as for taxes or consensus, or for a census. I can't say, oh, Jason, the tax auditor, you can't use my public data, my personal information, therefore I don't have to pay taxes. No, public interest as well. It could be with compliance with laws, such as a court order. I can't have a court order served on me because I refuse to give or refuse to have people use my personal information. No, that's allowed as well. Here's the one, though, you have to watch out for, and here's the one that's used quite a bit by companies: the legitimate interest of the data controller. So it's not consent. It's legitimate interest of the data controller, unless overridden by interests of the data subject. So if Jason is my employee, do I need to get his consent to use his personal information to make payroll? No, that's a legitimate interest of the data controller. If I need to prevent fraud or report criminal acts to the authorities, I can go ahead and do that. That's in the legitimate interest of the data controller. But be careful here, because this one is often challenged. This is the one where, remember, because consent was never given, this is the one where companies will have to be very careful not to overstep. Now, there's also a category of sensitive PII. We talked about that. And the general rule is this. The general rule is that there's no processing, none, of sensitive data, unless you fall under one of Article 9, and we're not going to go into that, but that's in the Article 9 of the GDPR. Article 9's exceptions. One of those, for instance, is explicit consent. That's one of the exceptions. One of the exceptions is not legitimate interest of the data controllers. You cannot use legitimate interest of the data controller as an exception to process sensitive information. Okay, so I know the GDPR applies to me. I'm a data controller or a data processor. I have a legal basis. I'm all set, right? Still not, right? Still not, because I have to make sure I follow the processing principles of the GDPR. I have to be clear and honest about what I'm doing with the data. I have to use only for the specific purpose which I have the legal basis for. If Mary gives me my legal basis of consent, and Mary says you can use it for A, I can't use it for B. That violates the purpose limitation. I have to use data minimization. Use only what you need for that purpose. Take only what you need. Use only what you need. It has to be accurate. I can't use half data or data with gaps. I have to use correct, accurate data. I can only store it as long as I need it. It's a storage limitation. Integrity and confidentiality. That's the GDPR's parlance for saying keep it safe and secure. And I have to be able, as I said before, throughout this process, to show accountability, to be able to demonstrate compliance with the GDPR. So that's how a data controller, data processor would properly use data. But the data subject, as we said before, has a lot of rights here. The data subject can say, within 30 days, I want all the data that you have. I want to see what all the data you have on me. And if you have 30 days to provide that as an organization, you do have, if it's a very high burden, or you can ask for an extra 60 days, but just a one-time give. So it could be up to 90 days, but generally it's a 30 days absent that 60 day. Now imagine if you have a division of 50,000 people, and all at once 5,000 people ask for that, which you have to provide in 30 days or 90 days at the latest. I mean, that could be very, very difficult to provide. You, as a data subject, have the ability to rectify. If there's mistakes in my data, if I ask for the data, I look at it, and there's mistakes, I have the ability to make sure it's corrected. I have a right to be forgotten. It's the right to erasure, but it's also called a slang right to be forgotten. Now, this is a very interesting one. The data controller informed recipients, unless it's impossible or disproportionate, unless you have a impossible or disproportionate effort as well. So same thing here. When I say forgotten, this means that the data controller not only has to erase my data, but also he has to, she or he has to erase all the data that was provided, that they provided to their recipients. Now that can be very, very difficult to do. If it's a social media post, who knows who received the photos or social media posts. So it could be impossible to do, but you have a right to be forgotten, at least with the data controller. You have the right to data portability. This is a new right under the GDPR. Basically, it allows you to transfer your own data between controllers. So if I have data and I want to move it from, I don't know, maybe Facebook to Snapchat, I am allowed to get the data in a structured, commonly used form. I have the right to restrict processing. Let's say I think there's mistakes in my data, which I need rectified. I have the right to restrict processing. I can object to processing as well. And I have the right to complain to the DPA. So those are the rights of the data subject under the GDPR. It's quite comprehensive. Much more, when I think of as an American, the rights I have of how people use my data, I think this goes, except maybe for HIPAA, this goes well above and beyond. Okay, so let's think about some questions here. So the first question, again, similar, about a year for the GDPR. According to the EBRD, how many cases requiring investigation have been raised across the 27 member states? How many cases? How many people have raised cases as a data subject and say, I think someone's using my data improperly? Is it 2,800, 28,000, 280,000, or 2,800,000? Mary, what do folks think?
We have C, we have B.
Yeah, C is the right answer. Yeah, again, C is the right answer. 280,000 times across the EU in 1 year, people have raised objections to how their data is being used. So you have to be sure as an organization that you have a strong legal basis for using that data and you're doing it in the right way. And you have to be very responsive to the data subjects' inquiries. Okay, we're going to go now to a case study. Before we do, Mary, are there any questions?
We did have a hypothetical question earlier. An EU citizen in the US receives urgent medical care. The US entity subsequent EU health insurance company, the EU, PII for the EU citizen selected by the US entity under the GDPR.
Okay, I'm not sure. Yeah, I'm not sure if I heard everything, but I did hear, because it was breaking up, but I did hear that it seems that there was the need for a U.S. company or someone to give personal information about someone, an individual in Europe, and could they do that? Did they have a legal basis for that? If I'm hearing medical emergency, oftentimes I think about, and we'll go back to it under legal rights, I think about this vital interest of the data subject, medical emergency. I'm not sure if that's, again, it was breaking up, so I'm not sure if I heard that correctly, but if they're asking what the legal basis would be to provide or access PII on behalf of an individual, one of those would be the vital interest rule. And
is the PII for the EU citizen collected US entity covered under the GDPR? I think that was the question. Yeah, so you were breaking up. Is the PII under the GDPR? Is PII collected under the GDPR? What is collected by the US entity covered under the GDPR? So the processing, so it's EU data which is sent over to the US? Is that right? It's an EU citizen that's in the US.
Yes, it would probably, but there's issues of a U.S. privacy shield, which it's the vital interest rule would apply, but also there's a U.S. privacy shield concept as well, which we're not going to get into today. I would have this person email me, and she or he can talk about potential issues there. Okay. Okay. So, folks, let's just stop for a minute, and then we'll go on to the go on to the hypothetical and finish for the night. Now, the GDPR is in effect. We know that it has certain territorial jurisdiction in the EU, as well as for companies doing business in the EU under certain actions, processing PII. We know that it applies to data controllers and data processors. We know that it applies for the use of PII, personal information. There's also different types of personal information. We know that you have to have a legal basis to process this information, and that there's also certain processing rules and principles you have to follow. We talked about those, about data minimization, for instance, data specific purpose. We also know that there's certain rights that data subjects have, rights to challenge how you're using those, rights to have you stop using your data, rights to have the data that you're using and processing. So there's certain rights as well. So now we're going to try and tie all this in to a case study. And this may look complex, but this is exactly how they look oftentimes when they come across your desk as a privacy officer. And this is very similar to what you would see if you took the privacy exam for Europe, this type of example. Okay, so I can't make the, Eric, no. Okay, so Greenbus is a US company. It's a US manufacturer of bus equipment and logistics software. That's Greenbus. We also have Vaduz Lines. Now, Vaduz is the capital of Liechtenstein. Vaduz is a bus company in Liechtenstein. Vaduz Lines purchases and implements Greenbus's new software. Now, this new software coordinates a company's bus mechanics with bus breakdowns by tracking the names and location of the nearest available mechanics, local mechanics, at their company-issued mobile phones. So I know, for instance, Jason is a mechanic. I can track him by his phone. I have a bus breakdown in town A. Jason lives in town A. I'm going to call Jason because he's closest, and I can have the bus back in action as quick as possible. Vaduz Lines never asked the employee's permission to track the 24-hour whereabouts. Vaduz Lines also asked Greenbus to store its mechanic information on their faster US database, which Vaduz Line then accesses via the software. Greenbus also uses the data for email marketing of its new products in Europe. So Greenbus says, why not? I'll just go ahead and use this data since I'm storing it and do some email marketing in Europe. Greenbus's CEO has heard of the GDPR on nightly news, but gave it no thought. It was a European law. She or he says, I'm a U.S. company, a U.S. citizen. I'm not worried about these European laws. The Vaduz Line CFO knows that the EU has a new privacy law, but believes it doesn't apply to their company, the Vaduz Lines, because it's located in Liechtenstein, outside the EU, and simply because they're a bus company. But it asks you for assistance, the folks on the phone, as a privacy officer. What possible GDPR issues do you see? Do you see any issues we didn't discuss or may have discussed quite lightly? As in any legal analysis, and this is true everywhere, look for the spirit of why the law was created. What is the law, the purpose of what the law is trying to do? Okay, so we're going to ask you to use your chat box, and Mary will help me out. Okay, question 1. The GDPR cannot apply to either company because Greenbus is in the USA. The GDPR cannot apply to either company because neither is in the European Union. GDPR can apply only to Greenbus. The GDPR can apply only to Vaduz Lines. The GDPR can apply to both. So what do people think?
People are thinking E.
Sure. It's kind of a softball for the first one, but that's right. So it can't apply, A, it can't apply to either company because Green Bus is in the USA. We've already said you can be a company outside or organization outside the EU and it still can apply to you if you do certain things. Cannot apply to either company because neither is in the European Union. Well, I think it was important what we said earlier. It's beyond the European Union to include the EEA, which includes Liechtenstein. It applies only to Green Bus. No, it can apply only to Verduz. It can apply to both. So E is the correct answer. I think that's good. That's people on the phone are using the simple tests we learned tonight as to the fact pattern. Okay, question 2. In the case example, the GDPR cannot apply aside from location, putting aside location, because neither company is controlling or processing PII. It can't apply in the case example, only Verduz Lines is controlling or processing PII. Only Green Bus is controlling or processing PII, or both companies are controlling and processing PII. Mary, what do people think on this one?
No one's answered just yet.
Well, they get tougher as they go along.
Someone said C.
Okay.
C. One person said D because data travels to the USA, maybe since they use those 7 servers.
Mm-hmm.
And yep, that's it. C or D is what's coming up.
Right. Okay. So the answer probably here is D. D is probably the answer because if we remember back, and this is confusing, we have Verduz Lines, which is using the personal data of their employees. So they're definitely a data controller. They may also be a processor in that they're using it off the web. I'm not sure if it doesn't say whether or not Green Lines is doing any processing or not, but they're certainly Verduz Lines is certainly a controller. Now, Green Bus is interesting in that we're supposed to be what looks like a processor, but they have decided on their own, sua sponte, to go ahead and use the EU data and then mark it inside the EU. So they have become a data controller and probably a data processor as well, though they're doing it improperly without a legal basis, most likely. And also there's discussions that we haven't talked about of whether or not they're even allowed to move the data over to the US. Okay, question 3. What would you suggest is the best way for Verduz Lines to obtain a legal basis for processing its employees' PII? What would you suggest the best way for Verduz Lines to obtain a legal basis for processing its employees' PII? So remember what a legal basis is. We're a data processor, data controller, but we need a legal basis to process. We have consent, contract, vital interest, public interest, compliance with law, or legitimate interest of the data controller, unless overridden by the data subject. Okay, so what's the best legal basis for Verduz Lines to process? Is it vital interest? Is it consent? Is it to perform a contract with Green Bus? Or to claim its legitimate interest of Verduz Lines as a controller? What do people think here?
People thinking B. One said D. Another said C.
Okay. Tricky stuff. Jason, what do you think? Is Jason on? No?
He might be on mute.
Might be a mute. Okay. So I think the best answer here is B. I think the best answer is B. It's probably not vital interest because it's not the vital interest of the data subject. There's no medical emergency. C is close, but probably not, because to perform a contract with Green Bus, remember the rule is for a legal basis is to perform a contract with the data subjects, right? Not necessarily with Green Bus itself. to claim its legitimate interest of Vaduz Lines as a controller. Now, this one you could claim, but you would probably lose if you got an argument with the data processing authority. Think about the spirit of the law. When those phones were given, when personal information was provided by the Vaduz Lines employees, was their intent, was their purpose of giving that, was the purpose stated of giving that to control and monitor their 24-hour locations? Probably not. Actually, in the fact pattern, it said they never got approval to or consent to do that. So it would be difficult to say that the interest of how the Vaduz Lines is using the data now, the purpose of using data now, was what was expected of the data subject. The bet, you could argue that, but it probably would not be a strong argument. The best one and the safest one here is to obtain express consent by the data subjects. Okay, and the last one: does Greenhouse have the right under the GDPR to use Vaduz Lines employees' PII? Because I'm laughing, I think you probably have an idea already. But does Greenbus have the right under the GDPR to use Vaduz Lines employee PII? Yes, because Vaduz Lines gave it to them. Yes, because European law does not apply to them as a U.S. company. No, because they have no legal basis to process the data. No, until they ask Vaduz Lines for company approval. Now to help you out, Vaduz Lines is probably monitoring individuals in the EU with this data, location data. They are probably, I think they were marketing as well. So they're offering goods and services to individuals in the EU. And they probably, without approval of Vaduz Lines, Greenbus is probably now going ahead and has become a controller on its own without asking for permission. So if we think about that, does Greenbus have the right under the GDPR to use Vaduz Lines employee PII? What do people think on this one, Mary?
C.
Yeah, I think that's right. They have no legal basis to do so. This is a classic case of a material miss, and they are now really violating some EU data privacy laws. But these four somewhat simple questions on this somewhat complicated fact pattern, which is a mess, but this is how they come to you. This is certainly how they look on the privacy exam. Shows it's a lot of ambiguity in the GDPR, and people can argue things different ways. I think that's why there's so many, inquiries going on right now. And data subjects are becoming more and more aware of the rights they have, and more aware of their ability to raise these issues with the DPA. So, Mary, that in a nutshell is the very basics of the GDPR. Now, if it seems like we didn't cover everything, that's because we didn't cover everything. There are cross-border transfers, the roles and responsibilities of a DPO, how to conduct a data privacy impact assessment, more on sensitive PII, which we just hit on very lightly. I've put a website, but you can go to the European website as well without this link. But this link just shows how to go to the GDPR official website. And we'll be discussing more of this in my class in a greater extent, more with greater applicability and practicality with examples. And this is the class below if you wish to sign up for it. It's been a pleasure talking to you about this subject. Sometimes this can be very dry, but I think we tried to make it interactive and very practical. Remember the basic test. If you're getting confused, go back, stick to the test on applicability of when it applies. Think about the rights of the data subject, think about whether you have a legal basis, and think about the principles of when you can process data. And Jason and Mary, that's it.
All right. Thank you so much, Joseph. Thank you for your time. Thank you again, everyone, for joining us tonight. It is the first time we are hosting our live lecture series, so please give us some feedback. If you have any questions about the presentation or about any of our programs, please contact me at admissions@albanylaw.edu. I'll also send you the video. And know that we are hosting online events. We have one on HIPAA compliance in October, as well as blockchain and cryptocurrency in November. You are all welcome to attend. Again, graduate admissions at albanylawschool.information. Thank you all so much for attending. Have the rest of your night.